today in this discussion, we will talk step-by-step guideline for VAWA self-petition. VAWA stands for Violence Against Women Act, but everybody must know that this law is not only applicable to violence against women, it is applicable to anybody who is suffering violence. It can be male, female, children, anybody. So a lot of time people ask me question, is it only applicable to women? Only women can apply for VAWA self-petition? The answer is no. Both male and children and women, all of them, they can apply for self-petition under VAWA. The first question is what you have to prove to be eligible to apply for VAWA. And here I have, I'm going to show you like a 5 criteria, but you do not need to meet all 5. If you just qualify for one of these 5, you can apply for VAWA self-petition. Number 1, you are currently married to a US citizen or lawful permanent resident who is abusive. And here, I want to tell one more information, which is a very vital information. You can only apply for VAWA self-petition if your abuser is a US citizen or permanent resident, meaning that person has green card. If you are a spouse of an international student or H-1B worker or O1, L1, all kind of non-immigrant status holder, you cannot take benefit of this application. You cannot apply for VAWA self-petition. Again, you can only apply for VAWA self-petition if your abuser, husband or wife, is a US citizen or permanent resident, meaning green card holder. The next one is you have got divorced from your US citizen or lawful permanent resident spouse within the past 2 years. So either you are married right now with your abuser, or you have been divorced for within last 2 years. If it is more than 2 years, you can still apply, but that would cause like a more problem, and you have to establish why you did not apply within 2 years. So remember, you have to apply within 2 years of this this abuse and neglect happened. The third one is you married your US citizen or lawful permanent resident spouse believing he was unmarried, but later found that he was already married. According to American law, one person cannot be married to multiple persons. Therefore, if you marry somebody who was already been married, then you can also apply for VAWA self-petition. And here I want to say a little bit about this marriage, like it's a family law issue. I'm not going that deep into family law issue. A lot of time, husband and wife, they get divorced. Both of them know that they have been divorced. However, according to law, they are not divorced yet. So if you know that you're going to marry somebody who was married before, you must make sure that his or her previous marriage has been ended. The divorce has been completed. Otherwise, your new marriage, the marriage you're going to do, it's not a valid marriage, but you can apply for VAWA petition. So it's like if you do not know, then you can definitely apply for VAWA self-petition. It has some benefit, definitely. You married to a US citizen spouse who died within the past 2 years. See, there is no permanent resident. If you are married to a US citizen spouse who died within past 2 years, you also qualify for VAWA self-petition. However, if your spouse was a permanent resident who died within last 2 years, then you do not qualify for VAWA self-petition. The last one, you married to your US citizen or lawful permanent resident spouse, but she lost her immigration status within the past 2 years due to domestic violence. So this is another category. Your spouse, either permanent resident or citizen, lost his status, immigration status, because of domestic violence, then you also qualify for VAWA self-petition. So these are the 5 categories. If you qualify just one of those, then you can apply for VAWA self-petition. So you must remember this requirement. If you qualify for any of these criteria, now you have to prove to the USCIS that your marriage was in good faith, aka bona fide marriage. So again, bona fide marriage is also like a very important thing in any kind of marriage-based application. Bona fide marriage means it was in good faith. You married this person for the purpose of being, live together and staying together forever, having a family, raise kids, kind of that intent, not for any immigration benefit or any other kind of benefits. So a lot of time for a lot of family-based application, especially marriage-based application, you have to establish that your marriage with this US citizen or permanent resident was a bona fide marriage. And this is a legal term. Please remember this thing. Now we're going to talk about a step-by-step guideline. So VAWA self-petition has two steps. The first one is called I-360 and the second one is called I-485. In I-360 application, you have to establish all the requirements of VAWA, meaning you have been abused physically or mentally by your US citizen or permanent resident spouse or children or any relationship. Once it is established that you are qualified for VAWA application, then you go for I-485 application. If you are the spouse of a US citizen, you can combine these two steps together. One I-360 and one I-485 together. It is called concurrently. You can also apply for semi-concurrently, meaning you are submitting your I-360 today, and then after like 1 or 2 months, you're submitting your I-485. So if your spouse is a US citizen, then you can either apply for concurrently, semi-concurrently, or one after another. That is okay. However, if your spouse is a permanent resident, meaning if your spouse has green card, then in most of the time, you cannot apply I-360 and I-485 together, meaning concurrently. You cannot do that. You have to follow visa bulletin. Again, I'm not going that detail into visa bulletin. That is a totally different discussion. Visa bulletin is very important. I advise all of you to know how to read the visa bulletin, follow Department of State website for visa bulletin thing. But the short point here is, if your spouse is a permanent resident, then when you will be able to apply for I-485 depends on the visa bulletin. If it is current at this moment, then you can apply those together, I-360 and I-485 together. If it is not current, then you have to get your I-360 approved. In your I-360 application, you will get a priority date. You have to check when your priority date is current in visa bulletin. Only then you will be able to apply for I-485. So please remember this distinction between whether you have a US citizen spouse or a permanent resident spouse. So now step one, I-360. In the first step, I-360, of course, you have to fill up the form I-360. It's a very self-descriptive form. You can, when you read it, you can fill it up by yourself. But if you need expert opinion, I advise you to contact a expert immigration attorney. Also, every form of USCIS has a instruction form. So every form has a instruction that you can download from your USCIS website. Those instructions are very easy to understand. Also, there's a lot of YouTube video and other places. So I know it's not that very hard, but again, I advise everybody to take help from expert immigration attorney because they know a lot of things. With this form I-360, you have to submit few documents. There is no fixed number of documents. Try your best to submit as much document as you can. Like number one, a declaration describing your relationship, the abuse you suffered, your good moral character, and anything else relevant to providing your eligibility. Write a declaration, like a statement, and try, if possible, submit it with a notarized version. So take it to a notary public, sign in front of the notary public, and submit that notarized copy to USCIS with I-360 form. Other evidence of the abuse, such as police or hospital record or court-issued protective order, this is also very important. I advise my clients to get a police report and hospital record. It is really, really helpful to get your I-360 approved. Office clearance record, sorry, there should be a P, it was my mistake. The police clearance record showing your criminal record or lack thereof. You can obtain the certificates from the police department of any town you have lived in during the last 3 years or more than 6 months. So you have to prove that you are in good moral character. You do not have any criminal record or any other kind of bad thing in your background. So to prove that, you have to get police clearance report. Any place you lived for more than 6 months, you have to contact the local city police department and request a police clearance report. They have online system. There's like a fee, I don't know, like $50, $100 kind of depending on city. Apply for that, get a copy, and submit with your I-360 application. Also, prove that the abuser is a US citizen or green card holder. This is very important because, as I said in the beginning, to qualify for a VAWA petition, your abusive spouse must be a US citizen or green card holder. So you have to establish. If you do not have any document that he is a US citizen or permanent resident, you can submit a sworn affidavit saying that I know that he's a citizen, or I know that he's a permanent resident, and you have to submit a notarized copy, but you have to submit at least some kind of document. Then prove that you are the abuser's spouse, child, or parent, marriage or birth certificate. So you have to submit the marriage certificate or birth certificate or any kind of document. Prove that you lived with the abuser and you currently live in the US. Remember, to apply for a VAWA petition, you must be in the US and you must have lived with this person for at least some time. Next one is include a cover letter on top of the application describing how you meet each other. Requirement and the evidence you have submitted to prove it. File the VAWA petition with the Vermont Service Center. So again, the Service Center may change. Always follow the latest guideline from USCIS website. Service Center may change, form may change, required document may change. Immigration thing is keep changing all the time. So please pay attention to all the latest changes and follow the latest guideline. USCIS will not interview the petitioner about his/her VAWA self petition, and there is no court date. So the petitioner will not have to testify about the abuse. USCIS will decide whether to grant your self petition based on the written evidence submitted. This is why it is very important to provide sufficient evidence. Since there is no interview, there is no court hearing, there is nothing later that you can establish more. So try your best to submit as much information and document possible with your I-360 application, because later you will not get more chance to add anything. So this is a very important note. There is no fee required to file I-360. This is a good thing. Currently, the fee to file for I-485, which is the second step, is $1,225. But the fee for Form I-485 can be waived if you satisfy some particular condition. Many of you already know that those who make less money, those who are not making enough money, U.S. government has provision that you may get your USCIS application fee waived. So there is requirement to do that. You have to fill up a form, submit your tax document with that. So if you qualify for that, you can also apply for I-485 fee waiver. It depends on your situation. But yes, if you qualify, why not you take the opportunity? Now we come to step number 2, I-485 application. I assume that you already have a approved I-360. Of course, you have to fill up the form I-485. Similarly, the form I-485 is also self-descriptive. It has a instruction how to fill it up. With this I-485 application, if you already have a I-360 approved, submit the copy of the approval. Also, 2 passport style photograph. If you are submitting USCIS fee, try your best to submit a money order or cashier's check. Personal check is not recommended. However, if you do not manage cashier's check or money order, then personal check or credit card information is also okay, but I do not recommend those things. A copy of a government issued photo identity document, for example, your driving license, passport, or any kind of photo ID. A copy of your birth certificate. If your country's birth certificate is not recognized as primary evidence by USCIS, then you have to submit other documents like your testimony from your friends and family about your birth. It is called birth affidavit, or any other kind of document like your school document, your church document, or any other kind of documents. But try to submit a birth certificate and some other documents. Documentation of your immigrant category currently filled, pending, or approved Form I-360. As I said, if you have approved I-360, you have to submit a copy. If it is pending, submit a copy of the pending or other kind of documents. Disposition on criminal charges, arrest or conviction, if applicable. A lot of things for I-485 depends on if it is applicable. If it is applicable, you have to submit it with your application. If it is not applicable, just skip that part. Form I-601, waiver of inadmissibility, if applicable. Again, I'm not going that detail into Form I-601, waiver of inadmissibility, because that is not the focus of our discussion today. Some other day, I will discuss about waiver of inadmissibility. Documentation regarding J1 and J2 exchange visitor status, if applicable. Again, if it is not applicable, just forget about that part. Form 508, waiver of diplomatic rights, privilege, exemption, and immunity, if applicable. Again, if not applicable, just forget about that part.